On the floor, next to Zaon Collins' basketball shoe, an unsealed container of marijuana.
We are on the record in case A218444652C, the state of Eric Echevarria versus Zaon Collins and Marvin Collins. Can I just have counsel go ahead and just say your names all on the record?
Ramzy, Ladah, Plaintiff.
Joseph Chu for Plaintiff.
Stephanie Zinna for defendant Zaon Collins. Here with me is Paterno Geroni.
Brett Johnson, Tyler Watson, on behalf of Marvin Collins.
Okay, we are outside of the presence. And you guys said you wanted to make an additional record beyond what we made yesterday afternoon. Before we do that, what we broke yesterday, as far as exhibit 72001, Ms. Zinna, you said you wanted to check and confirm that was in fact the right page. Were you able to do that?
So with respect to that exhibit, there was, Mr. Ladah did tell me there was a line there that, and I don't remember exactly what it said, but I'm of the opinion that it needs foundation before it can go into an opening. And Mr. Ladah can proceed how he sees fit if he believes it's coming in regardless.
Okay, so you're not stipulating to that,
Not
right?
stipulating to that table.
Nothing has changed. Okay. Okay. So additional record the council wanted to make. You can stand or sit. I do not mind either way.
If it's okay, if I just talk about the proposed jury instruction from yesterday, and Mr. Johnson's holding it if you'd like to see our proposed jury.
I would love to see a copy of it. You can read it if you want, but it'd be even better if I could actually read it while you're reading it.
Yes.
Okay. So go ahead.
Okay, so because we do have parties and sometimes counsel, quite frankly, because there's going to be times where we collectively, Mr. Watson might not be here, Mr. Johnson might not be here, just collectively.
Oh, sorry. I did say we're outside the presence, right? I don't know if I can.
You did.
Okay, just want to make sure I'm saying that. Okay, go ahead.
So during the course of this trial, parties and their attorneys potentially will be stepping in and out of the courtroom or will not be here for certain days. So we would just like the jury to be advised. I don't often use this as an official instruction. It's usually just something the judge tells the jury. But given your request, this is our proposed language for what we would like to say to the jury, that this is a normal, typical thing that happens in civil trials, and that we request that they hold it against neither party.
Okay. Is there a stipulation to this instruction?
No, there's not.
Okay. Why don't you read the instruction?
The instruction is, during the course of this trial, it may become necessary for the parties and their counsel to step away to attend to other matters. They are not doing this to be disrespectful to you. Everyone will do their absolute best to be present for each stage of the trial. However, that can not always be possible. I instruct that you are not to hold a party or their attorney's absence from trial against either side.
Okay. So this is different than what you were asking for yesterday, because what you were asking for yesterday was an instruction, I think, specific to your client, Zaon Collins, that would have also potentially covered one of the decedent's children who might be missing or who has also been missing from this trial for a similar reason, which is school obligations. So I'm correct that this is a different proposed instruction than what you were talking about previously.
So I don't believe it's different. The basis for why I was requesting this instruction was because Zaon may not be able to appear every day in person, and I know that Eric Jr. may not be able to appear, so I felt it was beneficial to both sides for those known reasons. But this covers both sides, is a neutral statement to where we're not singling out either side and giving anybody, more deference to the jury from your Honor's instruction.
Okay. Do you want to say anything about it, Mr. Johnson, before I ask for plaintiff counsel to give me their input on this? And I'm not trying to cut you short. I assumed you were done. Are you done?
I am done, Your Honor.
Okay. Go ahead.
Sure, Your Honor, and it's also, Mr. Watson and I had different responsibilities in this trial, and so he's not being here.
Okay, you need to speak up. I need to stay in your microphone because I can almost guarantee you that was not caught. Alternatively, we can give you one to wear on your lapel if you're going to be soft-spoken the whole time, but then you got to remember to turn it on and off when you don't want people to hear you. So why don't you start from the beginning and either stay seated or speak loudly, or do you want us to give you the lapel mic?
I'll tell you what, I'll stay seated. Your Honor.
Okay, fine.
Your Honor, well, that is louder.
Yeah, much better.
Mr. Watson and I have different responsibilities on this trial based on our availability, and very rarely will we be here both at the same time. So I didn't want the jury to be confused that there was no counsel here. And that has been my standard practice. Not that it matters to this court, but the court informed the juries of that fact. Typically hasn't been in a jury instruction, but it has been disclosed to the jury that the attorneys coming in. It doesn't address Ms. Keenan's specific concerns about witnesses not being here all the time, but I think it's very important that it be included. Thank you.
Okay. Plaintiff's counsel response.
Our response, Your Honor, is we are not asking for instruction to remedy the fact that one of our clients cannot be here every single day. We think it's appropriate to have that explained on the stand. It's within the jury's province to evaluate that, evaluate if it's a fair excuse or not a fair excuse, evaluate if it's credible or if it's not credible. This is an incorrect statement of the law. I have no problem with this regarding attorneys. When it talks about the parties, it's an inaccurate statement of the law because the jury can evaluate whether it's appropriate for a party to be here or not be here when they're prosecuting or defending their case. And I think there's instructions on that in the standard instructions on credibility. And there is case law, I believe, where the jury has the province and the ability to evaluate why, whether it's valid, whether it affects their credibility, that a party is or is not in the courtroom for the entire trial.
Anything else before I let them give them the final word?
The last thing I'd like to say, Your Honor, if, because this is just sprung on us now, if Your Honor is somehow inclined to give this, I would at least ask for the opportunity to brief this issue before Your Honor gives this as an instruction from the court.
Okay.
So again, the proposed instruction is as neutral as it possibly can be. It applies to both sides. It applies to everybody in the courtroom equally. It does not single out, okay, if Zaon Collins can't attend trial and can't be here, you can't hold it against him. It just says, hey, we're gonna do our best to be here collectively as counsel and parties. Don't hold it against anybody. And then the jury can still decide whether or not, if Mr. Ladah wants to question Zaon on why he hasn't been here yet, he can do that. However, just a standard instruction that they don't just get to start out by saying, hey, Mr. Watson wasn't here a couple of days of the week this week, Zaon hasn't been here yet. They're not already starting with those preconceived notions given the tenor of the jury's selection. I believe this would remedy any potential prejudice in the most neutral way possible.
Mr. Johnson, you want to say anything else?
Sure. I mean, it's plain they're trying to take advantage of the fact that Zaon's not going to be here and make a big issue out of it. When we went through all of this the other day, they want to make that part of their case is have
It's plain. They've said that their client's not going to be here for a large part of this too. And their
right,
client was already been missing for parts of this.
right. But their client's here in town, our client's out of town. So it's much easier for him to come and go here and has been able to present himself. Our client has not. That's always been a concern of ours. So it's not sprung on anybody, maybe the proposed.
But that's not your client either.
Yes, Your Honor, but one of the cases is derivative and my client gets impacted by it.
Okay.
And for that reason, that's always been a concern of mine. I've got my client here and then it's almost like, well, why isn't the kid here? So that's a major concern. I think it's going to prejudicially impact us, and under the unique circumstances of this case, I think that jury instruction is appropriate. Thank you.
Okay. So I guess my first question is, and I don't want anybody to stand up and respond to this with, well, this is a normal instruction given in trials or whatever else, because I'm going to be frank. Like, I tried over 50 cases before I became a judge. At least I was part of more than 50 trials, over 30 of which I was first chair. I don't recall ever having this instruction that I suggested or that someone else suggested. We just dealt with it where attorneys got up and asked during voir dire, are you going to
is this gonna create any problem for my client or for me if I have to walk out for a minute, if I have to do this, and we would just ask them in voir dire. So please don't get up and say this is a standard instruction that everybody gives, because I believe all of us have different experiences here and probably have different numbers of trials behind us. And maybe this is something other people are giving. This isn't something I've given in the past, and this isn't something that, I mean, I think word for word, I'm not sure if I've even ever seen this instruction. So, what I want to hear right now from counsel is, do you have any authority, rule, law that supports this? And if so, what is it? What's the case? What's the rule?
So, Your Honor, and I apologize if you misunderstood my comment earlier. I've actually never seen this in an actual instruction either, because it is something that, generally speaking, in my own personal experience, when we know that we're gonna have attorneys kind of bouncing in and out and witnesses bouncing in and out of the courtroom, that it is just generally something that other judges have done in trials that I have been in. So
When
it's
counsel
not a
stipulated to
standard-
it, or
No,
when
it's
it was disputed?
neither, because it was just, both sides had parties missing for both days.
Uh-huh.
And because of schedules in life, and the judge said, yes, absolutely, we will just tell we will say, this is normal course, people bounce in and out, and they're not doing it to be disrespectful to you or insult you for your time. That is my own experience. So like I said, I've never seen it in an actual instruction, so I don't have any case law for it handy, because it's never been gotten to this point where I had to propose an actual instruction for it. However, it has just been my experience that if there is an issue where parties and or counsel are having to come and go or appear different days or split the duties, that the jury is just instructed that is something that they can expect, and they shouldn't hold it against the parties.
Okay, Ms. Johnson, you want to say anything? You don't have to, but I'm just giving you the option.
No, Your Honor, I think we made our point clear. Thank you.
Okay, and from the plaintiff side, are you aware of any case law, rule, authority of any kind that either supports giving this or supports not giving it?
I'm not aware of any case law, rule, or authority that supports giving it, Your Honor. As far as not giving it, there are standard instructions on credibility that I believe conflict with this. That's why I believe this is, if I had given the opportunity to do some research, I hope I could find some authority that actually says this is inappropriate, that a jury can take into consideration whether or not a party is present. And if you think about it the other way, Your Honor, let's say a party's claiming a brain injury, a plaintiff is claiming a brain injury, and plaintiff doesn't show up to trial, and the plaintiff's counsel decides to hide the plaintiff in some other state. I think the defense can comment on that. So the fact that someone is not at trial or is not at trial certain days, I think the party should be given the opportunity to explain through testimony, and then they can make the arguments consistent with the evidence at trial. But there is, I don't believe there's any authority that supports giving this instruction, Your Honor. I think there's authority actually the other way. And I can't cite the authority right now, other than the fact that there's jury instructions on credibility that I believe conflict with this. But like I said, I'd like the opportunity to do the research.
Okay, you guys want to say anything more?
Just one final thing, and I am unaware of any authority that would conflict with this instruction. And I don't think that plaintiff's counsel's scenarios are applicable here. I think we both heard, we have parties that are going to be missing. And at least on our side, we are going to have attorneys that are going to be sharing duties and missing trials sometimes. And the attorneys can't get questioned either. So we don't get to explain why we aren't here for a day. Because Mr. Johnson is attending his daughter's graduation in Texas. And so he's going to turn the reins over to Mr. Watson. We don't get the luxury here to explain it. So it's just a simple statement. And again, I've never had to propose it in an instruction. It's just a simple statement to the parties or to the jury that we're not attempting to be disrespectful to them or their time. But this is just the reality sometimes of how trials get scheduled and how life goes. Thank you.
Can I clarify something on that point quickly?
Go ahead.
I have no objection to it regarding attorneys. For talking about attorneys or counsel. My objection is limited to parties, if that makes sense, Your Honor.
It does make sense. And I understand your analogy. I also understand Ms. Zina's point that it may not be a fair analogy to compare defendant to plaintiff in such a way where we're talking about a plaintiff claiming injuries and then a jury being precluded from observing that plaintiff in an everyday sense or during the course of a trial. However, here's my thoughts on this. And we initially continued this trial to allow Zaon to attend, and this was one of the dates. The May 5th start date was one of the dates that was given as a date when he could attend. So I'm not saying he isn't in finals, but this trial was initially continued to this date with the requests so he could attend because he had finals, giving me the impression initially that his finals would be done by this date, which is why we set it for this date. Additionally, there were other things brought up as well, but that was one of the reasons. So I want to preface by saying that. I'm also going to say that if this was stipulated and both counsel were in agreement, I would give it. But both counsel are not in agreement here. I'm not being given any authority, rule, law, or anything of the like to support it. Like as I said, I'm not sure that the comparison is a fair one when we're comparing a plaintiff who's claiming an injury to a defendant. But nevertheless, I think the way this could have been dealt with or should have been dealt with, and I think it was somewhat with attorneys asking in voir dire, are you gonna draw any conclusions here? And then the proper step is to take steps after that, making for cause strikes or proposing for cause strikes or using your peremptory challenges accordingly. And nobody was precluded from asking about this in voir dire. And this wasn't an instruction that was proposed prior to voir dire as an agreed to instruction. So I'm not inclined to give it at this time. My ruling is without prejudice. So if you want to bring it again at the end, we will take time again and discuss the instructions at the end. You can make a better record and you can bring up plaintiff counsel. You can bring up the research that you want time to pull. Maybe defense counsel, you can pull some research to support why this should be given as well. And the earlier you could submit that to me so I can review those cases too, the better. But at this time, I'm not going to give this instruction as it's not stipulated to, and I don't have any case law rule or any other authority to support doing so. With that being said, any additional preliminary comments before we bring the jurors in, or actually before I check and make sure they are all here and ready to go?
We do have some objections regarding the defendant's PowerPoint slides. We did exchange PowerPoint slides. I
Okay,
don't know if you want to wait till I'm done with my opening to go over that in a break, or if you want to do that now.
well, let's find out if she has any objections to yours first, since yours is going to be given earlier, because how long do you think yours is, Mr. Ladah?
Without objections, it's 45 minutes, Your Honor.
Okay, so the right thing to do probably, well, I know I said I wasn't going to give them a lunch, but I am going to give them a break. And I think the right thing to do is probably me read my initial charge, you do your opening, we give them a 15 to 20-minute break to stretch their legs, get their blood flowing, maybe get a cup of coffee or something. And then we move on to defense's opening. So let's talk about if you have any objections to his first, because we're probably going to take a break before yours, and we can address those objections then if we need to. Let me also find out if they're all here. Let's see if I got any kind of message saying they're all here.
Yes, Your Honor,
They're all here. Okay, great.
Judge, we have an extra copy of our PowerPoint. I believe Mrs. Zinna does as well for the court as you requested yesterday.
Okay, well,
We have the same.
my clerk needs one to file. But as we're doing these, I'm probably gonna need to see it. Do you have an extra beyond that extra or just the extra?
I have an extra.
Okay, so if I can have a copy of each of yours too, and if you want to approach and go ahead and give them to my clerk as well, that would be great.
No problem. Thank you. Appreciate it.
Okay, so Ms. Zena, Mr. Johnson, any objections to their opening?
Yes, Your Honor.
Yes, Your Honor.
Do you need to be in the room for this, or can I go ahead and start? Okay,
Oh, okay. So in plaintiff's PowerPoint, we have, and I counted, I believe, 15 photographs of the crash.
Okay.
Starting at page 5 of 95 of this PowerPoint. And it's just, it gets to be very excessive and prejudicial at that number of photographs, and they're very similar in nature, depicting the same thing over and over and over again. So our objection there would just be excessive and overly prejudicial for the number of photographs included in the opening.
okay. Hold on a second before you move on.
Okay,
Did she discuss this objection with you yet?
we had not had a chance to yet because we.
Okay, that's okay. What's your
Sorry.
position on the objection, knowing
Well,
what she's saying?
those are all pre-admitted, Your Honor. I go through them rapidly because I just want the jury to see the different angles of the crash scene. It's
was trying to find
when
it,
they,
but
in order to understand this crash, Your Honor, because the two cars go through a wall.
Are
And
any of them the physical body scene, the physical body photos that
No.
I limited?
no, Your Honor,
Okay, so they're all just crash scene.
correct.
And that was
Okay.
the court's only limitation, Judge, was that we are not allowed to show any pictures that depict the body for purposes that are solely to inflame the passions of the jury. And there was no limitation that was sought or given by Your Honor as it relates to just the pictures of the crash themselves.
Okay, and you said you plan on showing all 15 of these photos. Approximately how long are you gonna spend on each photo?
1 to 2 seconds.
Okay, and none of them, do any of them have people in them?
No.
Okay,
Oh, are there firefighters?
well, what I'm more concerned about is do any of them have an injured person in them?
No, Your Honor, definitely.
Okay, and is the firefighter, somebody who's gonna be testifying in this trial?
No,
Is the firefighter identifiable?
no, it's from the rear.
Oh, so you can't see his face, his or her, sorry.
I believe so.
Okay, if you can't see a face, then I'm not.
I'm pretty sure you can't see a face, but I can look through one more time to make sure.
Yeah, I just want to make sure we're not, obviously not highlighting another person that isn't even gonna come as a witness that wasn't on that list too. I mean, I know that's not a concern that was just brought up, but I'm a little bit concerned about that. If it does show a face anyway, you can blur it quickly. If it wasn't a person whose name was on that list.
Sorry.
And I do give an instruction. Which I don't know if I've gone over with council, but I will say it because of how much stuff you guys are having in your opening. That is the following. Can I read this while you guys are doing that, or do you want me to wait?
Go ahead, Judge.
Okay, during the course of this trial, you may notice or observe redactions, whited out, blacked out sections, or even crossed out sections of photographs or documents shown to you or read to you. There are various reasons for these redactions, including but not limited to privacy and adherence to court rules. Telephone number, license plate, social security numbers, addresses, as well as some additional information are not supposed to be shown in open court or admitted into evidence. Accordingly, you're instructed not to attempt to determine what information may or may not have been redacted, and you're not to consider it in this matter. Does anybody have an objection to them being read that instruction as part of the initial charge?
No objection from
No.
plaintiff.
No objection.
There
Okay.
is one picture we saw that does show a face of firefighter. We are blacking out or blurring it out right now.
Yeah, if you can blur it, that'd be great. Just to avoid that.
And the other.
Let me see how you show the 15. Oh, sorry, are we done with the 15 objection, or can I make comment about it? Are you?
Yes,
ready to
I'm
move on?
sorry, yes.
Okay, let me see how you show the 15. I understand her objection. It depending on if you really are only gonna spend 1 or 2 seconds, we're talking a total of 30 seconds for all of them.
Correct.
Okay, let's see how it plays out. I'm not inclined at this time to preclude them as, what was your issue, that they're gratuitous or excessive?
Yes.
Yeah, I'm
and
not
overly
inclined.
prejudicial.
And overly prejudicial. Okay, I'm not inclined to preclude them at this point for that reason, especially when they're pre-admitted photographs that I believe are also going to be shown. I'm assuming that whoever took them is going to be on the stand at some point, and you're going to say, did you take these at the scene? Or were you skipping that part because they're pre-admitted?
Because they're pre-admitted, we weren't planning on having to do that.
Okay, so they're admitted. Are they going to be shown through any other witness too later on?
Potentially.
Potentially, yeah, through one of our clients saw the crash scene, trying to think.
Thanks.
The Metro officer saw the crash scene, will be testifying, so they'll probably mention the photos.
Okay. Okay, so yeah, I'm overruling that right now. What's the next one?
So starting at pages 74 through, I believe, 82, there's a series of slides that, puts up Zaon's credibility as the title. Oh, go ahead. I'll wait for you to get.
No, it's fine. I'm almost there. Go ahead, I'm listening to you. Okay.
Or Kaz, can we get that back before we make an exhibit, just so we can have something to reference?
Oh. Oh, because you don't have one in front of you?
Sorry, we didn't bring it.
You printed two, Judge.
You're talking about this, right?
I could just look over.
Yeah, I can share.
It's okay?
Yeah.
Okay.
Yeah, no problem. Okay, so starting at slide 74 and it goes on through slide 82, I believe. These slides are argumentative. They discuss the credibility of Zaon with, true false options, and then the same slide is shown as a blank true false, and then it's shown as false with credibility of Zaon being front and center. And we think it would be inappropriate, that would be argument for opening statement as to arguing the credibility of witnesses. There's also another reference on credibility on 92 of 95, where again, the title of the 91 and 92, where again, the title of the slide is credibility. And then there is a big stamp across it that says false in red letters. So again, that would be argument and inappropriate for opening statement.
Okay, response.
I don't believe it's argument, Your Honor. The way I do it is the evidence will show, this is what he said in his deposition. The evidence will show this is what he said at the scene. The evidence will show this is what the facts are. We believe the evidence will show that this statement is false, and you get to evaluate his credibility.
Okay, so wait. So Zaon Collins made the statement somewhere,
Correct.
okay? So evidence is gonna show he made the statement and this is false. That's what
Correct.
you plan on saying?
And the evidence will show that that statement is false. And we actually show the statements, the places where he makes the statements, Your Honor. Through either pre-admitted exhibits or through the deposition, his video deposition, and an RCP 32A3 says deposition of a party can be used for any purpose.
I'm not saying you can't use these statements or say that these statements are gonna come out. But I don't know about, I'm just thinking about how, if this is argumentative because of, so you're gonna say evidence will show he said this and this was false.
Right. Evidence will show she said this, and evidence will show that his statement is false.
And what's the credibility title about? And I'm asking because it's like, it's not super clear by just the slide, you know?
The credibility is
He has
whether
credibility issues?
his credibility issues, whether these statements that he made, 4 different statements, are true or false. And they'll show where he makes the statement each time and show the evidence that's been pre-admitted that shows that it's an untrue statement. I'll say the evidence will show that it's false.
Your Honor, if I may.
Go ahead.
At least as to some of these statements that they're pulling from, Zaon didn't have some of the information available to him as to some of the mechanics. So he felt at the time he wasn't driving that fast. We know that's not true. That doesn't make him a liar. He just truly didn't know, didn't remember. So I think this would be more appropriate if they put him on the stand and he contradicts himself, they can impeach him, but to preemptively impeach him before he even testifies is just plain argument and prejudicial to the case. So, and I think Mr. Johnson wants to say something as well.
Your Honor, this is attorneys commenting on the credibility of witnesses. That's inappropriate from the start. The use of the red letters and the stamps, that's closing argument, Your Honor. This isn't what the evidence will show. It's not laid out that way. It's laid out as argument and it's inappropriate in an opening statement. And for that reason, we object to those slides. Thank you.
Okay. This isn't said like it's a pulled out of his depot. It's Zaon Collins was driving at 45 miles an hour on Ford Apache leading up to the crash. So evidence will show Zaon Collins said he was driving at 45 miles an hour on Ford Apache leading up to the crash. Like what is?
Correct. Each one is a statement that he made, and then I show, after I put just the Dan Collins was driving 45 miles an hour, I show where he made the statement, and then I show what evidence contradicts it. So it's a three-part, for every one, it's a part one showing the statement, and that's what that is. Part two showing where he actually said it. Part three showing what contradicts it.
Oh, the blank is what you're gonna show that contradicts it, like a video or something?
Correct. You got it.
Okay, so the blank is a video.
Video or something that's been like his deposition, a video deposition, or the body camera footage that's been pre-admitted. So it's all, the evidence will show this is what he said, the evidence will show this is what the actual evidence is, the evidence will show what he said was false.
So I have a few problems with this. First of all, the body cam footage is not testimony under oath. And that we're talking about a 19-year-old kid who had just gotten into a major car crash. That's not what he's repeating at the scene as he's in shock from an accident and he himself is injured is not testimony under oath that he can be impeached with. If counsel wishes to cross-examine him, as I'm sure he will, about those statements, but to argue that for counsel to argue credibility in an opening statement based upon footage of a 19-year-old kid that he gave at the scene of an accident to police officers, and then later testified maybe similarly or differently, that is beyond what I think is well beyond what I think is appropriate for opening statement. But to use, and again, I understand they want to use this deposition testimony for some of this, and I agree that deposition transcripts can be used for certain purposes. But again, calling into question counsel's opinion that Zaon is not a credible witness in an opening statement is inappropriate, and they are free to impeach him on the stand and then circle back to this in closing if they feel that's appropriate. But putting that out there that Zaon Collins is a liar because I said so, and based upon these videos that we have that you're not going to see any context for, is absolutely inappropriate, inflammatory, and overly prejudicial.
The videos are all pre-admitted too, aren't they?
Yes, you are.
But again, it's not testimony under oath. It's not something he sat down, raised his right hand and said. He's in shock after an accident. I think I was going this fast. And we know that's not the case at this point because we have experts who have measured the speed. But to say that he's lying because he was asked by a police officer at the scene, how fast do you think you were going? That's a stretch.
And I want to make sure I'm clear. I'm not using the word lying in my opening statement at any point. My opening statement is to give a roadmap of the issues and the evidence. And one of the forms of evidence is the evidence I'm presenting that's being contradicted. What he said and what the actual evidence is on that each topic. Because credibility is a primary issue. I can give the jury a roadmap on the credibility issues in the case, and I'm doing it.
I will let you right here. Evidence will show credibility is an issue in this case. But I don't just want the title of this slide to be credibility. You have to retitle these slides.
Okay.
Evidence will show, and then whatever you want after that. Evidence will show, I don't know what you want to say there, or you can just say evidence will show
I'm happy
the
to,
following.
I'm happy to change the title of the slides to each one to evidence will show, Your Honor.
Yeah, I think it's evidence will show, or if it doesn't make sense to say evidence will show, Zaon Collins has said, well, whatever you want to say, Zaon Collins, sorry, I keep saying his name wrong. But it's hard for me even just looking at the slide to understand it as like, without the argument around it anyway, but if, I think the title of the slide should be something to the effect of evidence will show. I know that makes the title too long, but,
I'm actually happy to take out the title altogether if that's helpful, Your Honor.
and you're gonna say Zaon Collins is gonna allege he was driving at 45 miles an hour on Fort Apache leading up to the crash. Evidence will show this is false.
Correct.
Okay, I'll let you say that. Take off to credibility or put evidence will show instead of credibility. But yes, credibility should not be the title of these slides. I don't know what the argument, besides what they're telling me right now, I don't know what the argument that's gonna surround this. Okay, but, or I shouldn't even say argument, the opening statements that will surround this. But the opening statements, please be careful. They should not be argumentative. Now, some of the other stuff you were bringing up from the defense side. Look, if they say that the evidence will show something in opening that's wrong or excusable or whatever else, you get to throw that all out in your closing argument. That's fair game for closing argument. They told you in opening, boom. And we've shown you in the trial, this, okay? Okay, other than this issue, what's the next issue?
And I just want to make sure we're on the same.
Sure, they're gonna take credibility off the slide, off of slides 74, 75, 78, 79, 81, 82. And I think that's it.
91 and 92, Judge.
Oh, okay.
Yes.
91 and 92.
That's what I wanted you to look at, particularly number 92, Your Honor. That's argument.
92. Let's take that.
That
Taking the title off. of 92.
Right, but this big stamp of false.
I can't even read what it says underneath it.
It's all the the 4 different statements that I'm going over them again briefly and just saying each of these, we showed you, you'll see the evidence will show each of these statements are false. It's
Then
basically
change the
to make-
title to, you'll see the evidence will show each of these statements are false.
Okay.
Okay, you'll see the evidence will show. Or evidence will show each of these statements to be false.
And removing the red stamp, Judge,
Um,
because we could just remove the title credibility as we did with the previous slides.
I mean, you can throw the red stamp up in your closing, but I think it's a little aggressive for an opening when it really, we should be avoiding argument. But you can write as the title, evidence will show the following to be false statements. If you want.
Thank you, Your Honor.
Your Honor.
Okay, any other ones?
Not from the defense, Your Honor.
Okay. Okay, you wanna, let's bring them in, let's do the opening charge and yours, so they're not waiting too much longer. And then I'll give them a 25-minute break, just so that they can go get an actual coffee and get back here without feeling like they have to sprint. And we'll do the other ones during that break, because I don't think we're gonna need more than a short comfort break, right?
That sounds.
Everybody's
appropriate.
okay? Okay, especially if we can possibly, are you guys okay to go, or do you want to break before we start? Good. Okay. Before we bring in the jury, what are council's agreement with regarding the exclusionary rule and people coming on Zoom? And are you all monitoring that, especially if you've given any of your witnesses or any of your experts via Zoom? Because we will do our best, but this is a public forum. We do ask people who come onto Zoom to please identify themselves, but we also need you as counsel, whatever rule you've decided upon, to make sure all of your witnesses and your experts are aware of that and that they're abiding by it, because although we can show it every once in a while, if you guys want to show your PowerPoints, we will not be showing Zoom. It's one or the other. So do council have an agreement with our regarding the exclusionary rule? I'm gonna ask you after I read the initial charge to the jury if anybody wants to invoke it, but do you already have an agreement?
There is no agreement, but we would want to invoke it anyway.
Same, Judge.
Okay, have you notified all of your witnesses, especially any witness that has the Zoom password, that they are not to sign on until you give them instruction that it's okay to come on?
Yes, Your Honor.
Same, Judge.
Okay, and you are invoking the exclusionary rule. Are you also excluding your experts, or are you agreeing that your experts can pop on and watch?
I would prefer it be exclusionary across the board.
Um,
You want to talk to each other?
No, I don't believe our position, Your Honor, I'm sorry. Our position.
You don't have to
Your
stand,
Honor,
but just let me know.
Our position is the exclusionary rule does not apply to expert witnesses.
I've always understood it not to apply to experts too, but at the same time, there are very few counsel that want to pay their experts to actually, I mean, that gets incredibly expensive.
True.
So, most time experts are not sitting on there, but, so is your position is that you don't have an agreement as to the experts, but you have an agreement as to everybody else. Am I
Yes,
clear?
sir. And I agree that the exclusionary rule does not apply to experts as well, so I don't.
You just
have
want it to if there's agreement.
Yes.
Okay.
But if Mr. Ladah does not agree to that, then I am fine. My only concern about the Zoom, as we discussed, is just making sure that we are showing who is attending the Zoom as best as we can. So the jury can see that Zaon is able to pop on when he can to further alleviate that concern.
Okay, can we go to the Zoom right now so council can see what it looks like if we were to go to the Zoom? Okay, so we've labeled, my staff has done it, which I very much appreciate,
Thank you.
observer to anybody whose name it's probably not a good idea to show for various reasons. Is Zaon the
He is
iPhone?
Not able to plug in today. I don't believe he is
Okay.
in finals all day today.
Who is the iPhone also, without giving me a person's name on the record, are they just an observer?
Don't know, they haven't checked in, I've sent multiple messages.
Okay, whoever the person is whose iPhone, you need to identify yourself to my staff. We're not gonna identify you on the record, but you need to identify yourself to my staff because we need to make sure that you're not a witness who's improperly on. Alternatively, you are welcome to walk into the courtroom and not identify yourself to anybody because then the attorneys will get to see you and can confirm by looking at you that you are not one of their witnesses. So those are your options. Please do one or the other. Or we're probably gonna kick you off. Give them 5 minutes. Let me get through the initial charge, and then when we get to the opening, kick them off if they haven't told you who they are. But like I said, and you guys can let everybody know this too, they can walk into this courtroom and they don't have to, as long as they are unobtrusive in this courtroom, they can sit here for the whole thing, as long as you guys can look at them and make sure they're not one of your witnesses. But I am concerned with the potential for witnesses to, okay, we got identification. Thank you very much. Okay, we're just gonna rename you as observer. And anybody else who's on, when you come on, put your name in the chat to my staff. They don't even tell me who it is. They just confirm you're not a witness, and then they'll rename you as observer if you haven't renamed yourself as observer. Okay, so please follow that going forward. This doesn't apply to Zaon Collins. He obviously can put his name, and I hope you've given him instructions of how you want his name on there, and he can follow that, and they will not change his name to observer. Okay?
Thank you.
And same thing goes for you, sir, or you, ma'am, if either of you ever want to jump on Zoom, because for some reason it's not going to be comfortable for you to be here or you're unavailable to be here. And same thing for you too, Mr. Collins. You are welcome to do the same thing. And if my staff changes your name to observer, just put in the chat. Please put my name back at whatever you decided with your attorney you want to identify yourself with. Okay? Okay. That being said, so you want that up like that while I'm doing the charge?
No, it doesn't need to be today because I know that Zaon won't be attending and we're going to be doing PowerPoints that's going to supersede that.
Okay.
And I understand that as we question witnesses, exhibits will get thrown up that supersedes that, but my request is anytime we can just default back to that screen, that's what I would appreciate.
I don't have any problem putting that up as a default, but I don't know how often it's gonna show. Does anybody else want to make a record as to that?
No, Your Honor.
No, Your Honor.
Okay. Okay. Let's go ahead and bring them in. Are they ready? Thanks. Okay, thank you. Everybody can please be seated. The council acknowledge the presence of the jury.
Yes, Your Honor.
Yes, Your Honor.
Okay, ladies and gentlemen, welcome back. We really appreciate you being here. My marshal is giving you, the camera is not on any of you, and it will not be on any of you at any time, okay? it aims at us and it films what's going on in the courtroom. But anybody filming in here knows that they are not permitted to film anybody in the box, okay? So please don't be alarmed by that. And if at any point you feel like you are being filmed, let my marshal know right away and we'll address it because no juror is supposed to be filmed. With that being said, thank you, ladies and gentlemen, for coming back today. We really appreciate you coming back and being so timely. We have done our best to give you each at least one side free. My marshal does give you instructions on where to sit. Part of it is because we need to make sure we can see all you at various times. If you are in a seat that is uncomfortable to you for some reason, or you need to move somewhere else, talk to my marshal about it. We want you to be as comfortable as possible, but we do have to keep you in that box because of where the cameras are aimed, and some cameras we cannot move. So with that being said, you should have notebooks on your chairs. Feel free to take notes during this trial. I'll give you some direction on that in a minute. As I said, throughout this, bring drinks in here, bring snacks. We will take about a 15 to 20-minute break this afternoon, so you can go run and get a coffee if you want. And we will just keep going from there. We're not taking a longer break than that today because we got you in here late so that you can have lunch before you got here. Okay, so here we go. What I will say to you now is intended to serve as an introduction to the trial in this case. It's not a substitute for the detailed instructions on the law, which I will give you at the close of this case and before you retire to consider your verdict. Ladies and gentlemen, this is a civil case commenced by a plaintiff against a defendant. This case is based upon a complaint filed by the plaintiff to which the defendant has filed a response, which we call an answer. Do counsel waive the reading of the pleadings?
Yes, Your Honor.
Yes, Your Honor, I apologize.
Yes, Your Honor.
Thank you. Ladies and gentlemen, you have no way of knowing what the facts will be presented to you during this trial, nor may any juror discuss with any fellow juror any fact relating to this case of his or her own knowledge. If during this trial you discover after the jury has retired or during any course of this trial that you have personal knowledge of any fact and controversy of this case, of any of the parties, of any of the attorneys, of anything else that you perhaps were asked about in voir dire, please let my marshal know that you have something to disclose. Do not discuss it with any other juror. Just bring it to my marshal and he'll bring it to my attention and I'll figure out how we're going to address it with counsel. Okay. This means that if you learn during the course of the trial that you're acquainted with any of the facts or with any of the witnesses, and you've not previously told us of that relationship, you then must declare that fact to me. And as I said, the way you declare that is just by telling the marshal, who will then bring it to me. Okay. The way you communicate with the court throughout this trial is through the marshal. He's present at all times when we are in session. He's who you check in with if you think you're running late, or if you have a question about parking or anything else. I told you this before, but during the course of the trial, the attorneys for both sides, the parties, and the court personnel, other than the marshal, are not permitted to talk with you. It's not that we are antisocial or don't want to talk to you. It's simply that we're all bound by ethics and the law not to speak with you because to do so might contaminate your verdict. We're not even allowed to say casual, how are you to you in the morning if we see you in the elevator. If we do say it, feel free to ignore us. It's probably an accident and we didn't realize we were talking to a juror, okay? So if we pass you in the hallway or in the elevator and we ignore you, or if you ignore us, it's totally okay. That's the process we should be following. Okay. While you're here in the courthouse, please always wear that blue badge. It is incredibly important because if you notice, there's no other way to identify the jurors, and we will have people walking in and out of this courtroom, and it is important that we know who the jurors are, so we can be a little more careful not to talk with you. When you arrive every day, if my marshal hasn't already instructed you to do so, go ahead and walk straight back into the deliberation room. You can sit in there, you can leave your stuff in there. No one else goes in there other than you all and the marshal. You can use the refrigerator in there. And like I said, feel free to leave your belongings in there if you would like. The door should be closed and locked when you are not in there. Okay. During the day, during lunch breaks, when you're in the elevator or walking around the hallways, please only talk with other jurors and never talk about the case. When you came in through the metal detectors this morning, like I said a moment ago, we have no way of identifying you as a juror other than those badges. So it is really important as soon as you get out of the car, please put the badge on. Whenever you are not back there in the deliberation room, we need you to be wearing the badge. Okay. If you should recognize a witness or realize that you're familiar with the facts of this case while a witness is testifying, please make a little note on that pad. You can fold up the pad and give it to my marshal and he will bring it to me. Okay. That's how we know that you've recognized a witness. Additionally, as I spoke about earlier, you will have the opportunity to ask witness questions at the end of all the lawyers' questioning, okay? But frequently, people don't recognize a witness by name in that big, long list I gave you, but they may recognize them when they come into the courtroom to testify. The person may be your child's soccer coach, or you only know them by a nickname, and maybe suddenly when you see their face, you recognize them. If that should happen, make a note on that pad, rip the paper out, put your badge number on the top, and give the note to my marshal. Okay. Additionally, I must tell you that you're not to visit the scene of any of the acts or occurrences made mention of during the trial unless specifically told to do so by the court. And in this situation, we are not going to tell you to go visit the scene. Okay. So you're prohibited from doing any investigation with regard to this case or with regard to anyone having to do with this case on your own. This seems like a simple instruction, but it's so simple that people sometimes ignore or overlook it. So what this means is that if something happens during the trial and there is some testimony or some evidence that you didn't understand clearly, and you know that maybe your best friend is an expert in a certain area, you can't call up your best friend at night and say, hey, in trial today, they were talking about X, Y, and Z. Can you give me some more information on that? Please do not do that. Additionally, you can't take out your phones and Google the scene or Google any of the witnesses or Google a word just because you're not sure what it means, okay? Please do not do that. Don't consult with Google, the internet, or any additional source for any information in this case. It's not that we don't want you to know everything there is to know about the case, but the problem is we cannot guarantee the accuracy of whatever authority you are consulting, okay? So because we cannot guarantee the accuracy of the authority you're consulting with, we simply ask you just not to do that. Okay. You're not to conduct any type of investigation on your own, including any computer aided research. You're not to discuss the case with any other person, any issue relating to this case, either in person, by Facebook, Twitter, email, texting, or by telephone, or by any other means of communication. Other than bringing with you your everyday common sense, you're limited to the documents and evidence which are presented to you during the trial. Okay. If your friends or family ask about this, just simply say I'm in jury duty. We expect to get out on the 22nd or 23rd. Okay. And we do know the limitations that some people have. So simply just tell them that you're not allowed to talk about the case while it's going on. Okay. The parties may sometimes present objections to some of the testimony or evidence in this case. At times, I may sustain objections or direct you to disregard certain testimony or exhibits. You must not consider any evidence to which an objection is sustained or which I have instructed you to disregard. It's the duty of the lawyers to object to evidence which they believe may not properly be offered. And you should not be prejudiced in any way against the lawyer who makes objections on behalf of the party which they represent. Anything that you may have seen or heard outside the courtroom is not evidence and must also be disregarded. Throughout the trial, if you cannot hear a question asked by an attorney or the answer given by a witness, please raise your hand as an indication. If I don't see your hand up, please say, excuse me, I didn't hear that. And we'll ask the question be repeated or simply just repeat whatever the answer was so that you can hear it clearly. During the course of this trial, you should be able to hear everything, but we do realize that the witness stand is way over here and some people are more soft-spoken than others. So please speak up immediately if you cannot hear something. Additionally, if at any point you need to stretch, if you need to wiggle your legs, if you can do so without any offense to your neighbor, feel free to do so. The people that are on the ends, feel free to get up and move around if you need to the extent you're able to without intruding on anybody's space next to you. You'll be given the opportunity to ask written questions of any witnesses called to testify in this case. You're not encouraged to ask a large number of questions because that is the primary responsibility of the attorneys. However, questions may be asked in the following manner. After both lawyers have finished questioning a witness, and only at that time, if there are additional questions you would like to ask, you should write your question down with your juror number on one of those full sheets of clean paper and raise your hand. All questions from the jurors must be factual in nature and designed to clarify information already presented. In addition, jurors must not place undue weight on the responses to their questions. The marshal will pick up your question and give them to me. All questions must be directed to the witness and not to the lawyers or to the judge. After consulting with counsel, I will determine if your question is legally proper. I will determine that your question may or may not be asked. No adverse inference should be drawn against either side if the court does not allow a particular question. Additionally, I will ask it exactly how you write it. So you need to write it exactly how you want me to ask it. Okay. During the trial, I may take notes of the witness's testimony. You're not to make any inference from that action. I'm required to prepare for legal arguments of counsel during this trial. And for that reason, I may take notes. Just because I'm taking notes doesn't mean any part is more or less important than any other part of this trial. If you wish, you may also take notes in the notebooks that you are given here. Full disclosure, we destroy all of your notes after this trial. So you do not take them with you at any point, and you leave your notebooks here every night when you leave. If you wish, you may take notes to help you remember anything a witness said. If you do take notes, please keep them to yourself until you and your fellow jurors go to the jury room to decide this case during deliberations. With regard to the notes, you should rely on your own memory of what was said and not be overly influenced by the notes of other jurors when you go back to deliberate. Do not be so concerned with taking a note that you miss another question or an answer of any witness. If you need to use the restroom or if you feel ill, please raise your hand as an indication. We will take intermittent breaks as the court sees fit, usually about every 90 minutes or so if you want, but we want you to be as comfortable as possible. So if that's not enough breaks for you, or you simply just need a quick restroom break, please let us know and we will take a break as quickly as we can. But every time you take that break, I do need to read you that instruction again. It's not because I don't think you know it. It's because I need to make sure I follow the rules and obligations that I have as a judge. Okay. This case will proceed in the following manner. First, the plaintiff will have the opportunity to make an opening statement outlining his or her case. After the plaintiff opens, the defendant has the right to make an opening statement if he or she wishes, or the defense may reserve its right to make an opening statement after the plaintiff has put on all of its evidence. Neither party is required to make an opening statement. You might hear two opening statements from the defense. It's not me favoring them. There are two defendants in this case, and they have two different attorneys. Okay. Opening statements are a synopsis of an overview of what the attorneys believe the testimony and evidence will be. Opening statements of attorneys are not evidence. After all, the attorneys are not witnesses to any of the facts and controversy in this case. After the opening statements, the plaintiffs will then introduce evidence and call witnesses. At the conclusion of the plaintiff's evidence, the defense has the right to introduce evidence if they so desire. After the defense rests, the plaintiff has the right to call rebuttal witnesses if he or she chooses. At the conclusion of all the evidence, I will instruct you on the law. You must not be concerned with the wisdom of any rule of law stated in these instructions or in the instructions which I will read to you after the evidence. Regardless of any opinion you may have as to what the law ought to be, it would be a violation of your oath to base a verdict upon any other view of the law than that given to you by the court. Please understand, ladies and gentlemen, the court does not make up the law. The law in each state is created by its state legislature and may be modified by the state Supreme Court. The court does not make up the law. I just tell you what laws apply to this case. After the instruction on the laws are read to you, each party has the opportunity to argue orally in support of his or her case. This is called the closing argument. What is said in closing argument is not evidence. The arguments are designed to summarize and interpret the evidence for you and to show you how the evidence and the law relate to one another. Since the plaintiff has the burden of proof, the plaintiff gets to argue to you twice at the end of the trial. Plaintiff will argue the defense, each defense attorney will get up and be able to give you argument, and then the plaintiff has the opportunity to rebut the defendant's argument. After the attorneys have presented their arguments, you will retire to select a foreperson and deliberate and arrive at your verdict. Faithful performance by you of your duties is vital to the administration of justice. It is your duty to determine the facts and determine them from the evidence and the reasonable inferences arising from such evidence, and in doing so, you must not indulge in guesswork or speculation. The evidence which you are to consider consists of the testimony of witnesses and exhibits admitted into evidence. The term witness means anyone who testifies in person or by way of a deposition, and it may include parties to the lawsuit. A deposition is simply an examination of the witness at a prior date under oath with the attorneys present, where the testimony was taken down in written format, and those written questions and answers may be read to you during the trial. Admission of evidence in court is governed by the rules of law. From time to time, it may be the duty of attorneys to make objections, and my duty as the judge to rule on those objections and decide whether a certain question may be answered or whether certain evidence may be admitted. You're not to concern yourself with any objections made by the attorneys or with the court's reasons for its ruling. You must consider testimony or exhibits to which an objection is sustained or which is ordered stricken. You must not consider testimony or exhibits to which an objection is sustained or which is ordered stricken. Further, you must not consider anything which you may have seen or heard when the court is not in session, even if what you've seen or heard is said or done by one of the parties or by one of the witnesses. In every case, there are two types of evidence: direct evidence and circumstantial evidence. Direct evidence is a testimony by a witness about what that person saw, heard, or did. Circumstantial evidence is testimony or exhibits which are proof of a particular fact, from which, if that fact is proven, you can infer the existence of a second fact. If a witness testifies that they just came in from outside and it was raining, that would be direct evidence that it was raining. If that same witness came in and didn't say anything about it raining, but you could see that they had a wet umbrella, wet clothes, and they were tracking in water with their wet shoes, those items of information would be considered circumstantial evidence from which you may be able to conclude that it was raining outside. You may consider both direct and circumstantial evidence in deciding this case. The law permits you to give equal weight to both types of evidence, but it's up to you to decide how much weight to give any particular piece of evidence. No statement, rule, remark, or facial expression which I may make during the course of the trial is intended to indicate my opinion as to what the facts are. I don't get to decide the facts. You are the ones who determine the facts. In this determination, you alone must decide upon the belief and believability of the evidence and its weight and value. In considering the weight and value of the testimony of any witness, you may take into consideration the appearance, attitude, and behavior of the witness, interests of the witness in the outcome of the case, the relationship of the witness to any party in the case, the inclination of the witness to speak truthfully or not, the probability or improbability of the witness's statements, and all other facts and circumstance and evidence. Thus, you may give the testimony of any witness just such weight and value as you believe the witness is entitled to receive. Let me remind you again that until this case is submitted to you, you do not talk to each other about the case or about anyone who has anything to do with it until the end of this case when you go to the jury room to decide your verdict. Do not let anyone else talk to you about the case either or about anyone who has anything to do with the case. If someone should try to talk to you about this case while you are serving as a juror, please report that to my marshal immediately, okay? You may need to tell your boss or your spouse or your significant other about what's going on, but all you can tell them is essentially you've been chosen as a juror in a civil case and that the judge has told you the trial is going to last until May 22nd is our goal. Okay. You may also tell them that if the trial's over earlier, you may be back to work sooner. That's really all you can tell them until after you have been discharged by the court. We also can provide you letters from the court if you need one. If you need one and you have not been provided one, just let my marshal know and we will provide you one. Do not make up your mind about what the verdict should be until after you've gone to the jury room to decide the case and you and your fellow jurors have discussed the evidence. It's important throughout the trial to keep an open mind. At the end of the trial, you will have to make your decision based upon what you recall of the evidence. You will not have a written transcript to review. Even though we have a court reporter or recorder down there at the end, Ms. Jackson, who I introduced you to earlier, she does record the testimony, but it's not typed up in a readable format right away. That takes much longer. And it's difficult and time consuming for her to go back and locate or read back any part of the lengthy testimony that'll happen in this matter. Therefore, I'd urge you to pay close attention to the testimony and evidence as it's presented. And that's why you have the notebooks as well to keep notes as you want to. Okay, I had one more instruction. During the course of this trial, you may notice or observe redactions, whited out, blacked out sections, or even crossed out sections of photographs or documents shown to you or read to you. There are various reasons for these redactions, including but not limited to privacy and adherence to court rules. Telephone numbers, license plates, social security numbers, addresses, as well as some additional information are not supposed to be shown in open court or admitted into evidence. Accordingly, you are instructed not to attempt to determine what information may or may not have been redacted, and you're not to consider this in this matter. Okay, that concludes my pretrial instructions. Does any party wish to invoke the exclusionary rule at this time?
Yeah, sure.
Okay, so if we have any witnesses in the courtroom, I just ask that you please leave right now. And I would just ask too that the council just take a look around the courtroom and ask anybody who they believe might be a witness to step out of the courtroom. Okay. Seeing nobody or anybody who left should be walking out. If anybody is on Zoom that is a witness, we're instructing you now to please sign off. Okay, at this time, we move to the opening statements. Council will proceed with an opening statement. Before he does that, does anyone want to stretch a little bit or stand up? If you do, please feel free to do so. But I also would imagine he doesn't mind if you do so during his opening statement, as long as you still pay attention and can listen. Okay, Council, are you ready to proceed?
Yes, Your Honor.
Go ahead.
Yes, it's on. Thank you. According to the National Highway Safety Transportation Commission, approximately 70 people die per year in Clark County alone as a result of drivers speeding on our roadways. What brings us all to this Clark County Courthouse here today are the driving safety rules that protect us all from serious injury and death on our roadways. Like all safety rules, these safety rules will protect us only if juries choose to enforce them. The safety rule in this case: drivers must not drive at excessive speeds on public roadways. If a driver violates this rule, crashes into another vehicle, causing serious injury or death to another member of our community, then that driver is responsible for all damages. Now, let me tell you why you're here. It's December 30th of 2020. It's a normal day here in Vegas. No adverse weather conditions. We're deep in the southwest part of Vegas. You may be familiar with the area. It's right around where Fort Apache and Blue Diamond are. Two other cross streets that you may be familiar with that are around there are Durango and Mountains Edge Parkway. Fort Apache, as you'll see, has a little side street that comes off it called Furnace Gulch. Furnace Gulch leads to a residential community right there. Number of houses. A 19-year-old named Zaon Collins leaves his mother's house in his father's gray Dodge Challenger. Only takes him a couple minutes to get from his mother's house onto Fort Apache Road. He's heading to basketball practice. He's going northbound on Fort Apache in that gray Dodge Challenger. The speed limit on Fort Apache there is 35 miles an hour. Dan Collins is driving 88 miles an hour in a 35. There's another car. A driver is driving a white Hyundai Sonata. He's going the opposite direction on Fort Apache. He's going southbound on Fort Apache. He's waiting to turn left onto Furnace Gulch to get to his house, which is right down, a few houses down on Furnace Gulch. Zaon Collins is plenty of ways away. So the white driver, the white Hyundai Sonata, attempts the left turn. But Zaon Collins is going too fast. He's closing in too rapidly. The last second, Zaon Collins, who's in the left lane, swerves to the right, just as the driver of the white Sonata is almost all the way through the intersection, almost down, clear of the intersection onto Furnace Gulch. Bam! The gray Dodge Challenger slams into the white Hyundai Sonata. They go flying, and they crash through the backyard wall of a house right on the corner of Furnace Gulch and Fort Apache. This is the aftermath. After the crash, 911's called. The Las Vegas Metropolitan Police Department come to the scene. They conduct a thorough investigation, and they search the gray Dodge Challenger, and they find on the floor next to Zaon Collins' basketball shoe an unsealed container of marijuana with a little bit of marijuana in it and some wrapping papers. Blood is drawn from Zaon Collins to see if he's over the legal limit in marijuana. And they detect two different chemical compounds indicating marijuana in his system. The first, THC. He has 2.0 nanograms per milliliter THC in his system. The legal limit to be behind the wheel and have it in your system is 3.0 nanograms per milliliter, you'll hear. And the second in his system is marijuana metabolite. He has 5.0 nanograms per milliliter of marijuana metabolite in his system. Legal limit for marijuana metabolite is, he has 32.4 nanograms per milliliter of marijuana metabolite in his system. The legal limit is only 5.0 nanograms per milliliter. So he's over 6 times the legal limit. He's charged and he pleaded guilty to count 1, reckless driving, and count 2, vehicular manslaughter. Now, it's an honor and a pleasure to introduce to you my clients in this case. And you'll hear Anne Marie Echevarria, my first client, moved to Las Vegas in the 1990s. She moved here with her husband at the time and her 3 children she had at the time. When she moved here, she had another child, but then her and her husband at the time grew separated and divorced. And that was a tough time for her because she was a single, struggling mom at that time, you'll hear. At that time, her youngest son, Jason, you hear about, Jason was in Elaine Wynn Elementary School, right here in Las Vegas, after she was divorced. And as Anne Marie would drop Jason off and pick him up from time to time from Elaine Wynn Elementary School, she would see this handsome young man walking around the school. And he looked like he worked at the school. And this man caught Anne Marie's attention, caught her interest. And you'll hear, then one day, after taking Jason to school, Anne Marie got a phone call from the principal. And the phone call was telling her, Anne Marie, Jason forgot his lunch at home today, but don't worry, someone bought him a lunch. She wondered, who was it that bought him lunch? So she wanted to go to school to make sure Jason had the lunch, but also find out who was it, this mystery person that bought him the lunch. So she went to the lunchroom and she found out the person that bought the person that bought Jason the lunch was that same handsome young man that Anne Marie would see from time to time walking around the school that looked like he worked there. And his name was Eric Echevarria. And you'll hear Eric Echevarria was loved by everyone. He was the maintenance supervisor at the school. And Anne Marie thanked Eric, and they hit it off. They became friends, and you'll hear they even started dating. And they dated for a while, and everything went great. But then you'll hear Eric had to go off to Army National Guard service in Fort Irwin in California. And Anne Marie asked Jason jokingly before he left, she said, Jason, are you going to remember me when you get back? And Jason went off to Army National Guard service, and they stayed in touch during that period of time. And you'll hear when he got back, not only did he remember Anne Marie, but he proposed, and they got married. And this is them right here, shortly after they got married. You can see their wedding photos in the background. Everything was great. Eric was the husband that Anne Marie always wished for. And you'll hear Eric was even good with Anne Marie's other children, especially the younger 2, Jason and Ashley. They called him Dad. And everything was going great. But then something different happened. They found out that Anne Marie was pregnant. And this was really exciting, especially for Eric, because he was excited to have a kid of his own. And 9 months later, Anne Marie gave birth to a baby boy. And they decided to name him Eric Echevarria Jr. And the moment that boy was born, him and Eric Sr. were best friends. They did everything together. They were inseparable. Everything and anything a father and son could do together here in Vegas growing up, they did together. Big Eric got to relive his childhood, little Eric. He took him to trampoline parks. They went to Wet n Wild together. Little Eric was really into trains, so they would go to toy stores and buy trains that they would assemble together. You hear the house had trains all over it. Little Eric was really into Thomas the Train, so they would even go ride trains sometimes. They would go to Dave & Buster's, arcades. Big Eric was spontaneous at times, so he'd even take the family on trips out of nowhere. Sometimes he would just say, hey, it would be a Friday, he would say, hey, tomorrow, why don't we all just go to Laughlin? Let's just go hang out in the pool for the weekend. Let's go to Knott's Berry Farm this weekend. This is them right here. Big Eric, Anne Marie, and little Eric in the background. You'll hear little Eric and Big Eric even saw each other at school sometimes, because whatever school Big Eric worked at, little Eric had the opportunity oftentimes to go to the same school. They would see each other at recess sometimes, lunchtime. Things were great. And then on December 30th of 2020, there was no school. So Big Eric and little Eric were home. And little Eric said, Dad, I'm hungry. Can you get me some food? And Big Eric, like the dad he was, said, what do you want, son? He said, I want Wendy's. He was really into Wendy's at the time. So Big Eric jumped in the Hyundai and went off to Wendy's. And he went through the drive-thru, and he was on his way back home. And it was almost 3 o'clock. At the same time, you'll hear Anne Marie was right around the corner at Albertson's grocery shopping for the family. And while she was grocery shopping, this is all happening in close proximity. This terrible feeling came over her. Something was wrong, like something terrible had happened. Feeling she's never felt before. And the first thing she thinks of is little Eric. So she picks up the phone, calls to make sure little Eric is okay. Little Eric answers and she says, Eric, is everything okay? He says, yeah, Mom, everything's fine, don't worry. And then she says, well, where's your dad, little Eric? He says, I don't know, Mom. He should have been back by now. He went to Wendy's to get me food. That worried Anne Marie. So she bought the groceries and walked out the Albertsons rapidly. And before she got to her car, she heard sirens screaming down the street in the direction of her house. She wondered what was going on. Jumped in her car, started driving to her house. As she's driving down Fort Apache, before she gets home, before she gets to Furnace Gulch, she sees the turnoff to Furnace Gulch is blocked off by a bunch of police cars and emergency vehicles with their lights on. So she pulls up to the first officer she could see. And she feels like she could see her husband's white car in the distance. Looks like it's through a wall. And she starts running towards the first officer she can see. And this is what happens next.
What are you looking for?
A Hyundai.
What color is it?
White. Come on.
I don't know. Who's
My
that?
husband is driving it.
Okay, let's move over here. Let me make sure that it's gonna be him, okay? Do you have your husband's name and information?
Echevarria. Oh my God, husband. So please.
Where did you come from?
Oh my God.
Let me. It might not be him. I don't know. Just breathe a little bit, okay? Okay, just give me 1 second, okay?
Okay.
Breathe. I'm gonna get as much information as I can, okay? I'm gonna try to help you out.
That's the body cam footage from the scene of her arriving after the crash. Anne Marie is eventually told that Eric had survived and he was taken to Southern Hills Hospital. This is him arriving in Southern Hills. Anne-Marie had to walk past that wall where the cars had been slammed through in order to get to her house on Furnace Gulch, because it was all blocked off. They weren't letting any cars through. So she walks past it to go home to get little Eric. And they have to walk back past it when they walk back to her car, when she walks back to her car with little Eric. And while she's walking past the wall, she tells little Eric, "Don't look. Don't open your eyes." They get to the hospital. When they get to the hospital, this is during COVID, so they only allow Anne-Marie in. She goes inside and she stays by Eric's side. And there she's told that he's struggling to survive. They're struggling to keep him alive. And Anne-Marie's other children come and pick up little Eric, take him home. And Anne-Marie's told after little Eric leaves that they have to transport big Eric to a higher level trauma unit so he has a better chance of survival. So they flight for life him from Southern Hills to Sunrise Hospital in a helicopter. And Anne-Marie goes to Sunrise Hospital, praying that there'll be a miracle that'll survive. Meanwhile, little Eric's at home with Anne-Marie's other kids. And when she gets to Sunrise Hospital, she gets the heartbreaking news that big Eric didn't survive. And she collects herself and she calls home. She tells Jason and Ashley, who are right by Eric's side at home when this happens. And they start crying when they get the news. And Eric sees them crying. At that moment, he knew his father didn't survive. And this is the death certificate. It says the cause of death was multiple blunt force injuries from that Dodge Challenger slamming into the white Hyundai at a high rate of speed, crushing in on Eric. The time of death, 18:01, which is about 6 p.m. Crash occurs a little after 3. So it's about 3 hours. 3 excruciating hours for the family. Praying, doing everything they can to keep hope that big Eric would survive. Only to find out they didn't. And you'll hear about those multiple blunt force injuries in this trial. What you'll hear is that he had a fracture in the left side of his temporal bone, left side of his skull. He had a fracture in the right side of his mandible, his jaw. He had a fracture in the base of his skull. Broken bones in the right clavicle, which is his collarbone. Broken bones in the right scapula, which is the shoulder blade. Multiple broken ribs on the right side, 1st through 8th. Middle of the chest was shifted right. It's called a mediastinal shift from the force of the crash, crushing in on his body. It also broke numerous ribs. Fracture of the 1st, 2nd, and 3rd ribs on the left side. And his thoracic spine was dislocated. All the result of the rapid speed of this Challenger slamming into him. So now I want to tell you who we're suing and why in this case. We are suing Zaon Collins because he was the driver of that gray Dodge Challenger. We are suing him because he chose to violate the safety rules that day. He chose to drive at more than 2.5 times the posted speed limit on our public roadways. And in doing so, he endangered the public. You'll hear about those safety rules in this case, and you'll hear about the excessive speed in detail. What the evidence will show is why excessive speed is so dangerous on our roadways. Because it makes it more difficult for drivers to react when they're going too fast if something happens on the roadways. Makes it more difficult to stop if someone starts at too rapid of a speed. They can't slow down fast enough to get to a low speeder to stop. Makes it more difficult for other drivers to judge space. Drivers assume that other drivers on the road are driving at reasonable speeds. If they're driving too fast, then they can't judge properly whether or not they can make a maneuver, like a left turn. And a high rate of speed, a crash at a high rate of speed makes it more likely to cause serious injury or death than a crash at a low rate of speed. Ultimately, what we intend to show is that the excessive speed in this case led to these catastrophic results. Or the simple truth is, speeding kills. But we're also suing Marvin Collins. Marvin Collins is Zaon's father, but we are not suing him because he's his father. We're suing Marvin Collins because he was the owner of the vehicle. He was the owner of that gray Dodge Challenger. What you'll hear is that he entrusted Zaon Collins with a powerful muscle car when Zaon Collins had a history of excessive speeding and reckless driving. You see that Marvin Collins, although he owned that vehicle, he let his son drive it. He even let his son personalize the license plate. What you see is it said Z-Slum, which matches with Zaon's Instagram handle. And you'll hear about that history of dangerous driving, in this case, that Zaon Collins had. You'll hear that just 2 months after he got his license, on 11/27/2017, he got his first citation for failure to pay full attention to driving. Here it is, right here. And then on 9/20/18, he was cited for going 21 to 30 over the speed limit. That's this one right here. And then on 11/20/18, he was given his next citation for driving 90 in a 65. Here it is. And then his next citation, he was given a ticket for going the wrong way on Durango on 6/19/2020. Here's that ticket right here. Driving southbound in the northbound lane on Durango. And of course, now you know about our incident where he was going 88 in a 35, and he pled guilty to reckless driving and vehicular manslaughter. The ticking time bomb with his history, his driving history. So, before we brought this case to trial, we needed to understand exactly how this crash occurred. So we took a look at the accident reconstruction. And we looked at the Las Vegas Metropolitan Police Department investigation. You'll hear that they came out, the fatal unit did a full and thorough investigation. And they gathered evidence and documented evidence of the scene. And we hired our own expert, a gentleman by the name of Sam Terry, who you will hear testify in this trial. And you'll hear Sam Terry is an accident reconstructionist. And you'll hear about his qualifications and his credentials. What you'll hear is that he's well qualified. You'll hear that he has 28 years of experience in accident reconstruction. He's been ACTAR accredited since 2009. ACTAR is the Accreditation Commission for Traffic Accident Reconstructionists. He's done thousands of reconstructions in his career. He's been qualified as an expert in numerous courts. He's never been excluded by a court of law, and he's performed accident reconstructions for the Department of Defense in death cases. And you'll see the first thing Sam Terry looked at was the black box data from that gray Dodge Challenger that Zaon was driving. And the same way, you'll hear the same way that airplanes have black boxes that record data before an event. Modern day cars have black box data that records events. And the black box data you'll see recorded Zaon's speed from T-minus 5 seconds up to the moment of impact for the 5 seconds preceding the crash. And at T-minus 5 seconds, you'll see Zaon was going 85 miles an hour. And from that, Sam Terry could reconstruct how far away from the intersection Zaon Collins would have been at T-minus 5 seconds. So he did that calculation, and you'll see he determined that Zaon Collins was 592.7 feet away from the intersection at T-minus 5 seconds, a long ways away. And to put that in context, what you'll hear, first of all, is that people judge the safety to turn based on the distance between them and other vehicles. It's called the gap distance. How much space do I have in between the cars coming from the opposite direction? Do I have enough space to make that left turn? They look at how much space they have. What you'll hear Sam Terry say also is that drivers cannot judge the speed of another vehicle coming at them from a great distance away. So if a car is coming at someone from a long ways away, from the opposite direction, it's very difficult to judge its speed. It just gets slightly bigger over time, you'll see. You can't really judge its speed until it gets really close. Versus if a car is going from our right to a left in front of us, we have things to place it in context with, stationary objects, other vehicles. But coming right at us, very difficult to judge the speed, you'll hear. And you'll see at that point, to put it in context, that distance, Zaon Collins would in fact have been a long ways away. That 592.7 feet. You'll hear that a football field is 300 feet long when we take out the end zones. So 600 feet is 2 football fields without the end zones. So it would have been almost 2 full football fields away at that point. More than enough space to make that turn, that left turn. So then, let's keep going. T-minus 4 seconds. He's going 86. He's increasing speed, not decreasing, increasing. And now, he's 467.1 feet away from the intersection. Still plenty of space for Mr. Echevarria to make that turn. Now, T-minus 3 seconds. He's going 87. Zaon Collins is increasing speed again. Now, at this point, Zaon Collins is 339.5 feet away from the intersection. Still enough space to make that turn. Now, at T-minus 2 seconds, this is where he reaches his top speed. What you'll see is between T-minus 5 and T-minus 2, Zaon Collins doesn't slow down. He increases speed. And now, he's 211.5 feet away. Still enough space for Eric Echevarria to make that turn, but he's closing in rapidly because he's going so fast. Now at T-minus 1 second, he's going 76. He's starting to slow down. So it looks like he started to slow down at T-minus 1.5. And now he's 90.3 feet away. Still would have been enough space for Eric to make that turn if he was just going a reasonable, if Zaon Collins was just going a reasonable speed. Now, T-minus 0.5, he's going 66. Obviously sees Eric, he's trying to slow down, but because he started at such a rapid speed, it's very difficult to slow down when you're going that crazy fast. And now he's 38.1 feet away. What you'll hear Sam Terry testify to is that Zaon Collins was not driving at excessive speed. This would have been more than enough space
safely complete the turn. Eric Echevarria would have been well onto Furnace Gulch. A crash never would have happened, even if by T-minus 2 seconds, Zaon Collins was going at reasonable speed. Even if everything else is the same and at T-minus 2 seconds, he's going at reasonable speed. So excessive speed, you'll hear, is the primary issue in this case. Going over 2.5 times the posted speed limit on our public roadways through residential areas. And what we intend to show is that reckless speed equals reckless driving, a conscious disregard for the safety of the public. But there's one other thing. It's that Zaon Collins swerves to the right at the last second. What you'll see is that he's in the left lane all along. The last second he swerves to the right. By doing so, he actually tracked Eric Echevarria through the intersection. And the crash occurs right almost on Furnace Gulch. And what you'll hear Sam Terry say is that if everything stayed the same, even if Zaon Collins was going that same speed, if he just didn't swerve to the right, Zaon Collins just stayed in that left lane, the crash wouldn't have happened. Eric Echevarria would have made it through without a crash. So, before we brought this case to trial, we also need to look at a few other things, a few statements that Zaon Collins made throughout this case. And you get to evaluate those statements. One of the statements he made, you'll see, is that he claims he was driving 45 miles an hour on Fort Apache Road leading up to the crash. And you get to determine whether that's true or false. And you'll see that these statements come from Zaon himself. You see, when the officers arrive at the scene, they have body cam footage on, or the body camera's on, and it catches what Zaon says to them. And Zaon's asked how fast he was going. He's actually asked by the paramedic that's right next to him. And this is what he says right here.
My car? 45, 48.
My car?
45, 48. 45?
He says he was going 45 to 48.
And then we got to take Zaon's deposition. And in his deposition, someone raised the right hand and swears to tell the truth, the whole truth, and nothing but the truth, so help him God. And this is what he said in his deposition about speed. Also pay attention to what he says about what the speed limit is there. When the collision occurred, how fast were you going? I don't know. Over the speed limit, but I don't know how fast I was going. You said over the speed limit? Yes. How much over the speed limit? I don't remember. How do you know you were going over the speed limit if you don't remember how fast you were going? Because that everyone goes over the speed limit on that road. So the way you know you're going over the speed limit when the collision occurred is because everyone goes over the speed limit on that road. Is that correct? Yes, I believe so, yes. While you're driving on that road, did you ever look at your speedometer to see how fast you were going? I don't remember. What is the speed limit on that road? I don't know. You don't know? No. But the black box data doesn't lie, it indicates his speed. And you get to evaluate that throughout the trial. So the next statement we took a look at was this statement where he says, So the statement that he was driving 45 miles an hour on Fort Apache Road, the evidence will show that that statement's false. You get to evaluate that. Next statement. Dan said he was driving the right lane leading up to the crash. And this is where he says it right here. Here it is. He also talks about the car in front of him here, so that's important as well to pay attention to. He says how fast the car in front of him was going. Claims it was going the same speed as him. Here it is. So there was another car in front of you. In the direction you're heading, there's a 2-lane road, you said? In the direction you're heading?
Direction I'm heading, 2-lane road.
Okay. And you were in the right lane?
Right lane,
Okay. There was another car in the left lane, in the same direction as you.
same direction.
How far ahead of you was the car in the left lane in the same direction as you?
I don't know.
Okay. But you know it was ahead of you.
Yeah, that's really good. I can see which direction.
Okay.
Speed ahead of the
So we took a look at whether or not he was in the right lane. And what you get to see is the police actually gathered some evidence. There's a video from a house right on that street. What you'll see is that, do it here. This right here is Fort Apache. This is Furnace Gulch over here, and this is the next street over, Gomer. I showed up here also. That's Fort Apache going that way. That up there is Furnace Gulch, and this right here is Gomer. And what you can see is that this actually catches the lead up to the crash. We can see 2 cars go by ahead of Zaon, and then you can see Zaon's gray Dodge Challenger go by in this video. So the first thing we looked at for the first statement was what lane was Zaon in? So here's the first car that goes by. Now the car that's ahead of Zaon goes by. Here comes Zaon. What the evidence will show is that he was not driving the right lane. He was in the left lane, and he swerved to the right at the last second. So the next thing, video we just showed you, he claims the car in front of him was driving the same speed as him. True or false? So video one more time. You get to pay attention to the speed of the vehicles. This is the car ahead of him right here. Now Zaon goes by. And what you'll see is that Sam Terry could take from that video exactly how fast the cars were going from the video footage. What he determined is that the car ahead of Zaon was going a little over that 35-mile-an-hour speed limit, but not much. It was going about 40 miles an hour. While Zaon in that video is, in fact, going 88. So he was going more than double the speed of the car ahead of him, not the same speed. So what the evidence will show is that that statement is also false. So the next statement that Zaon claims, he claims he did not use marijuana the day of the crash. So you get to evaluate that as well. Now, of course, it's not illegal to use marijuana in Nevada, but it is illegal to get behind the wheel of a car when you're intoxicated over the legal limit. So this is the body cam footage, and you can hear what he says to the officer about marijuana usage.
Okay, so just okay, nothing to drink or anything like that? No marijuana, no, okay.
So he
So he says no marijuana.
And then here he's actually asked about his marijuana
history usage, and he's asked if he used marijuana that day. You'll hear he says he uses marijuana occasionally, but he did not use that day. Here it is.
I'm Officer Powell, okay? We're going to be doing an investigation, all right? So, right now, I'm going to be checking for any impairment. Did you smoke marijuana today? None at all? Did you drink today?
You smoke cigarettes? Drink alcohol?
Did you smoke weed today? Be honest.
So then we asked him in his deposition similar questions. We asked him if he ever smoked marijuana before the crash. And before this crash, he never smoked marijuana.
No, I never smoked marijuana, no.
Okay. Then we asked him to clarify whether he had any marijuana usage history. This is what he said. You have no marijuana usage history?
No.
Okay. Are you saying you never used marijuana before this crash happened, before the December 30th, 2020 crash occurred?
Correct. That's what I'm saying. I never used marijuana.
Never?
No.
Not a single time?
No.
Okay. So before December 30th of 2020, you never, not a single time, ingested marijuana, correct?
Inhaled or ingested as well?
Well, inhaled, let's start with that.
No, never inhaled, no.
So before December 30th, 2020, you never inhaled marijuana?
No.
Okay. Before December 30th, 2020, had you ever ingested marijuana?
Not of my knowledge, I didn't know I was ingesting the marijuana. No, I didn't, not know, but yes.
Okay, how many times before December 30th, 2020, had you ingested marijuana?
One time.
When was that?
It was days prior to the accident.
What you'll see is that Zaon claims that days before the accident, days before, he went to a friend's birthday party and someone handed him a gummy. And he likes gummies, so he took it and it had marijuana in it and he didn't know it had marijuana in it. And he got a little dizzy and that's the only time he had marijuana and that's why marijuana was in his system. So we had to evaluate that. We know Zaon Collins tested positive for marijuana. That's what the evidence will show. And the evidence will show he was over the legal limit when the crash occurred. These are the toxicology results. Same results I showed you before, but these are the actual results instead of just in a PowerPoint table. A toxicology expert will testify during this trial. Well, you'll hear him say, his name is Dr. Raymond Kelly. He's an expert in the field. He's well qualified and credentialed. He has a PhD in biochemistry and molecular biology from the University of Oregon. He did a postdoctoral fellowship in forensic toxicology. He was the director of toxicology at Associated Pathologists. He was the laboratory director at American Toxicology, Inc. He was the president of the California Association of Toxicologists. He was a fellow at the American Board of Toxicology, and he has been the Nevada licensed laboratory director in Nevada since 1995. What he will testify to is that these toxicology results are consistent with marijuana usage 0 to 6.5 hours prior to the crash, not days before the crash. He will testify that even low doses of THC impair cognitive and psychomotor tasks associated with driving. And he will testify that Zaon Collins was likely impaired, and his impairment would have significantly interfered with his ability to drive in a safe and prudent manner that day. So what the evidence will show when he says that he did not use marijuana the day of the crash, the evidence will show that's false. We intend to show that all those statements that we just went over, that each one of them are false. Ultimately, we intend to show that this was preventable. We are here to hold the defendants accountable for their actions. And we don't know what they're going to say today. But up to this point, you'll hear they've been refusing to accept responsibility for their actions. No accountability. You will hear from Eric Echevarria's co-workers. You will hear from his friends. And you will hear from his family. You'll hear about his life. You'll hear how much he was loved. And you'll hear how much he loved others. You'll hear how much everyone enjoyed having him around. How helpful he was to everyone. How good-hearted he was. You get to evaluate all those damages we talked about earlier. You get to evaluate the economic damages, which are the damages you can put in an Excel spreadsheet and write out. The loss of probable support, or the loss of money that he would have made for the rest of his life working, he would have given to his wife and to his child, Eric Echevarria Jr. The cost of his medical expenses before he passed and his funeral expenses. But those are a tiny part of this case. The smallest part of the damages. The biggest part of the damages in this case are the intangibles, the human element, the grief, sorrow, the loss of comfort, loss of society, loss of consortium for the wife, Anne Marie. Anne Marie lost her knight in shining armor that day. Eric Jr. lost not just his dad, but his best friend. And you, the jury, get to evaluate the value of a man's life. The value of a husband's life to his wife, and the value of a son's life. Sorry, the value of a father's life to a son. Thank you for your time. I appreciate it.
Okay, ladies and gentlemen, at this time, we are going to take a brief break. I'm gonna give you long enough where if you need to, you can go get a cup of coffee or soda. And as I said previously, feel free to bring them in this room. When you come back, you're gonna hear, defendants are prepared to do their opening today, right?
Yes, Your Honor.
Yes, Your Honor.
Okay, you're gonna hear defendants' opening statements. So at this time, I gotta read you an instruction and then I'm gonna release you. Give me just a moment. You're instructed not to talk with each other or with anybody else about a subject or issue connected with this trial. You're not to read, watch, or listen to any report of or commentary on the trial by any person connected with the case or by any medium of information, including without limitation, newspapers, television, the internet, or radio. You're not to conduct any research on your own relating to this case, such as consulting dictionaries, using the internet, using reference materials. You're not to conduct any investigation, test any theory of the case, recreate an aspect of the case, or in any other way investigate or learn about the case on your own. You're not to talk with others, text others, tweet others, Google issues, or conduct any other kind of book or computer research with regard to any issue, party, witness, or attorney, or anyone else involved with this case. You're not to form or express any opinion on a subject connected with this trial until the case is finally submitted to you. Okay, that being said, you are on a break. It is now 2:23. I'm gonna ask that you come back at 2:45, please.
All rise for the jury. Ladies and gentlemen, please leave your notebooks.